Madam Speaker, through you and to the members, I rise in support of House 140, an act relative to abusive practices to change sexual orientation and gender identity in minors. Thank you, Mr. Speaker, for prioritizing this legislation and bringing it to the floor so quickly. I'd like to recognize the gentle lady from Newton, who has long championed this cause. We had a lengthy hearing on this bill last week, heard a great deal of testimony. There were many personal stories and points of view. But all views were heard and all voices were respected. That's a testament to the able leadership of our chair, the fellow members of our committee, and the many individuals who took the time to testify. The medical science case for banning so-called conversion therapy is well documented. Others have spoken very powerfully on this topic, so I'd like to focus my remarks on the legal case. First, I think it's important to review what this bill does and does not do. This bill prohibits state-licensed healthcare providers from attempting to change a minor's sexual orientation or gender identity. The bill does not prevent religious or faith leaders from offering pastoral counseling to adults in any way. The bill does not prevent religious or faith leaders from offering pastoral counseling to minors in any way. It does not prevent state-licensed providers from counseling adults in any way. It does not prevent state-licensed counselors from speaking in public about conversion therapy. It does not prevent state-licensed counselors from expressing their own personal views about conversion therapy. It does not prevent state-licensed providers from discussing conversion therapy, even with their minor patients. It does not prevent state-licensed providers from offering informational literature about conversion therapy. It does not even prevent state-licensed counselors from recommending conversion therapy for their minor patients. It does not penalize, sanction, or otherwise impose any new burden, regulation, or condition on a parent or a minor. It does not subject anyone to criminal liability. It also does not include any mandated reporter language. The bill does not give more powers to DCF. It does not allow the state to label parents as abusers, or take children away from their parents, or order gender reassignment surgery and hormone treatment, or impose ideological mandates on counseling, or any of those other brazenly false claims that have recently been raised. The bill does one thing, which is to prohibit the practice of state-licensed healthcare providers from attempting to change a minor's sexual orientation or gender identity or advertising such services. That is all. Now, in the past, some opponents of this type of legislation have tried to claim that a ban on conversion therapy violates free speech rights. The facts, however, do not support that conclusion. In fact, federal courts have repeatedly upheld conversion therapy bans on First Amendment grounds. In 2013, the Ninth Circuit Court of Appeals ruled in favor of a California law banning conversion therapy for minors in a decision known as Pickup v. Brown. The Circuit Court upheld the law again in 2016 in the related case of Welch v. Brown. In 2014, the Third Circuit Court of Appeals ruled in favor of a similar New Jersey law banning conversion therapy for minors. That bill, interestingly enough, was signed by Governor Chris Christie. In all three cases, the U.S. Supreme Court had an opportunity to weigh in, but rejected appeals and let the decisions stand, most recently in 2017. Today, there are conversion therapy bans on the books and in place in 14 different states, plus the District of Columbia. Another question that has been raised is the issue of talk therapy. During our past debate, some suggested that we should ban any form of so-called adversive therapy but carve out an exception for efforts to change a person's sexual orientation or gender identity through, quote, talk therapy. I appreciate that this may be a good faith concern, but I would respectfully say that that is a false distinction. Again, all of the medical and scientific evidence tells us that attempts to change a person's sexual orientation or gender identity via psychotherapy can be just as harmful. But let's put that aside for the moment and again look at the legal case. There is simply no legal basis for exempting psychotherapy as a form of conversion therapy. Keep in mind that the purpose of psychotherapy is not to provide the therapist with an opportunity to talk about his or her own personal views, but to provide treatment to a patient. Talk therapy is a form of treatment, not speech. I'd like to quote from a ruling in the Third Circuit. The practice of most professions, mental health professions in particular, will inevitably involve communication between the professional and her client to handcuff the state's ability to regulate a profession whenever speech is involved would unduly undermine its authority to protect its citizens from harm. Now, finally, I'd like to address a more recent Supreme Court decision which some opponents have attempted to cite in support of their position. In the case of Nifla v. Becerra, the Supreme Court in 2018 overturned a California state law mandating that pro-life pregnancy centers advertise the availability of state-funded abortion services. The court found that this was a compelled speech regulation that could not survive strict scrutiny. That case, however, is not at all analogous to the issue before us. Anti-conversion therapy regulations do not compel any speech, nor require any proscribed message. They regulate conduct. In fact, the Nifla decision, written by Justice Clarence Thomas, highlighted the state's well-established right to, quote, regulate professional conduct, even though that conduct incidentally involves speech. The bottom line is this. It is well within the state's authority to reasonably regulate the conduct of healthcare providers. That's the view of the Supreme Court, our federal courts, and our state courts. The bill before us today is closely modeled after the successful California law, which has already been vetted, litigated, and upheld multiple times. This bill is narrow in scope to protect minors who cannot meaningfully offer consent. It includes exemptions for religious and faith-based counselors. It places no burden on any parent and does not preclude anyone, even a state-licensed provider, from expressing his or her own free views. It simply prohibits a practice that every medical and scientific expert tells us is outdated, harmful, and ineffective. I urge a favorable vote. Thank you.